Hello YouTube, I'm Vince White. I'm an employment attorney and we have a comment question on one of our videos from a YouTube user named Brandy Thompson. And the question asks for a breakdown of what a pro se litigant should expect if representing his or herself in federal court. So, let me get the mic a little bit closer here. Hopefully that was audible. Seems like a useful thing. So I'm going to go ahead and make that right now. Essentially, as a pro se litigant, someone representing yourself in federal court in a discrimination or sexual harassment claim, you're going to need your right to sue letter, right? And from the day you receive that right to sue letter, you're going to have 90 days to get filed in federal court. So how do you file in federal court? Well, go to either your local federal court or their website, depending on how they run things where you are, and look at the requirements to file an action, right? And what's essentially going to happen is you're going to have to file a complaint. The complaint's going to have to set out your claims, your federal claims. Hopefully, if you're doing a really good job, you're going to be including all the viable claims, including like local claims, state law claims, all of which can be crushed into one case as long as they're packaged with a federal claim with that right to sue letter, and it can all be filed together in one case most of the time. So you file your complaint. You're going to get one of two things from the other side. Well, I'm skipping a step here. You're going to have to file your claim, and you're going to have to make sure that claim gets served, right? You can either do that through waivers of service, or you can do that through hiring a process server. That's a complex. This is an overview video, so that's complex. There's a lot to that. Certainly, you're going to want to research getting that done correctly, okay? Okay, so let's assume you filed your complaint. You've perfected service, everything's on the up and up, everything's done. You're going to get one of two things from the defendants. You're going to get either an answer saying, hey, we didn't do this. Or even, okay, maybe we did one or two of these things, but we didn't do most of it. Or, you know, who knows what they're going to say. But probably they're going to say, we did none of this, it's all lies, 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 none of this ever happened, the end. That's often what an answer will look like. Because if they don't deny things, well, they're kind of like admitting to them, right? The other thing they might do is file a motion to dismiss before they answer. This is very common for pro se litigants because your complaint might be defective in some way, or it might not be pled correctly. There's all these things that can happen, and they're trying to get your case dismissed. Don't be too disheartened by this, right? This is somewhat common for pro se litigants that they face a motion to dismiss right off the bat. Often, I hate to say it, often the motion to dismiss is going to be right on some things. You may not have filed your complaint correctly, you may not have drafted the complaint correctly, there may be fundamental failures in what you did. So read it, and you're going to have to create opposition papers. You're going to have to say, well, my claim shouldn't be dismissed, and this is going to be a big document. You're creating a big document to argue in opposition to their motion for summary, for a motion to dismiss, right? So what you're going to argue at its core is, hey, they're wrong, my case shouldn't be dismissed, but even if you think they're right, the case still shouldn't be dismissed, you should give me an opportunity to amend so I can get things correct. Assuming that you are either victorious on the motion to dismiss, or that the judge or the magistrate gives you time to amend, and your amendment is effective and there's not another motion to dismiss, then your case is going to start moving forward, right? A lot of jurisdictions you're going to have mandatory mediation. They're going to get the parties in with a mediator, set them down, and talk about settling the case. This may or may not be effective, but it's always worth time to take things seriously. Don't go in like, oh, this is a waste of my time. I want my day in court. Realistically, as a pro se litigant, it's going to be hard. It's going to be hard to get your day in court because there's so much you don't know, and there's so many little tricks they're going to try on you and everything else, okay? So take mediation seriously, if you can. If they're not making you real offers, if they're not making good faith offers, I get it. You're going to have to fight it out, right? You knew this was going to be tough from the day one, representing yourself in federal court, so, you know, you're ready to some extent for how difficult this is going to be. Let's say mediation's wrapped up, motion to dismiss is wrapped up, some of your claims or all of your claims survive, they're going forward. Generally, you're now going to be dealing with discovery, right? You're going to have to do, you're going to have to create interrogatories, lists of questions for the other side. You're going to have to create document demands, right? There will have been a conference that's going to set out the schedule for all this discovery, when these demands and requests have to be in by. Make sure you keep an eye on that scheduling order. Make sure you are complying with it. Realistically, if you miss some of those deadlines, you will be losing some of your rights. Some of your tactical advantages will poof, just gone, completely gone. So keep an eye on the scheduling order from whatever preliminary conference you had or scheduling conference, and comply with it. There's a whole host of different strategies for interrogatories. There's a whole host of strategies for document discovery. With document discovery, just ask for anything that could be relevant, right? Don't limit yourself. Let them argue with you. Let them try to fight you. If they're not giving you what you need, you're going to have to file a motion to compel to get what you need, right? Don't be afraid to, following proper procedure, make a motion to compel discovery, okay? Eventually, discovery is going to progress. You're going to have depositions, right? People are going to be questioned, including potentially you if you're the plaintiff, right? So you're going to be in the unenviable position of defending your own deposition if you're representing yourself. That could be very awkward, right? Different courts are going to handle that in different ways. This is a topic all of its own. You're going to have to look into this. You're going to have to prepare for this. On the other end of the spectrum, with you pursuing your case instead of you being questioned by the other side, you need to decide, who do you want to question? And what will you ask them? Prepare in advance. Don't go in being like, oh, I hope Toby gives me what I need in this deposition, right? That's not going to work. You need to actually know what you're going to ask Toby and have a strategy for how you're going to get what you need this hypothetical Toby character to say said. How are you going to get Toby to say the things that are true that you need? Okay, so let's say discovery's wrapped up. You're all done with discovery. Well, now you're probably going to face a summary judgment motion. And here's the wild thing about a summary judgment motion. The summary judgment motion is going to assume the facts of your complaint are true. Think about that. They're assuming the things you're saying are true. And the other side saying, even if they're true, you can't win. So there should be no trial here. The case should just be dismissed. That's wild. You're going to receive that summary judgment motion from the other side. You're going to have to oppose it. You're going to have to draft opposition papers opposing their request for summary judgment. And essentially the arguments you're making are, there is a question of fact here. We need this case to go before a jury, determine if these things happened, and if they happened, I could win. I could win my claims. I could win my day in court. That's a hyper-simplified version of the argument you're going to be making, but that is fundamentally at its core the argument you're making in your opposition to summary judgment papers. Now, assuming you're successful, some or all of your claims survive summary judgment now. What's next? There might be another settlement conference. There might be a big round of negotiations because the other side's going to be blown away that you, pro se litigant, got past summary judgment. Well done to you. Truly. Applause is well deserved here. So there might be a settlement, back and forth. There might not. Hopefully there is. If your case does not settle at this stage, you're going to start scheduling trial dates. There might be some motion practice pre-trial, but realistically the next big thing you're going to be seeing is the scheduling of trial dates. Conducting a trial pro se is an extraordinarily daunting task, but that is what is going to be before you at that point. Judges generally give a lot of leeway to pro se litigants. They're going to bend a lot of the rules of procedure for you to try to help you out, but things are still not going to be easy. You have a lot of preparation, hundreds of hours of preparation for an experienced attorney, so I can't even say how many hours of preparation for a pro se litigant who has never done this before, and that is going to be the next step here. Now, I don't want to dissuade anyone I don't, because sometimes being pro se is all you have, right? It's the option you have, and it's very important that you fight, right? But it is difficult. It's a difficult path, and I know somebody right now who's doing it, and I believe in that person a great deal, a great deal. But it's just hard. It's a very difficult process. So take settlement offers seriously, right? Don't be cavalier about it. You have to go in knowing you're doing a very hard thing. And if there's a way to get it done and get yourself paid and get the wrong righted, well, listen, hear that out, because it might be a good option for you. Now, this was obviously an extraordinarily high-level run-through, right? This was not digging down into the specifics here. I hope it's helpful. If it is helpful, consider liking and subscribing. Unfortunately, I am not a pro se help office, right? We get a lot of people who call us up like, hey, I'm trying to serve my complaint. How do I do that? I can't do that for you, right? Like, I'm here to help you. And if you want me to make a video, I can make a video, but I can't have that individual conversation with 100 different people per year, because that's going to be, 100 different people, 15 minutes per conversation minimum. Usually it's longer than that. That's 1,500 minutes per year of me walking people through how to serve a complaint. I can't do it. I have clients to help. I cannot do that for everyone. But I can try to make these videos that will try to help. So if you have questions and you want to comment below, I can try to answer those questions for you. If you have comments, just fly in here. Yeah, I'm always open to comments. Happy to have a back and forth in the comments down below. Like and subscribe. It helps us to help more people just like you. And good luck to you. Truly. If you're a pro se litigant, I am cheering for you. I want good things for you. Take care.